have with me in the studio Mr. Sanjay K Chadha, Senior Advocate, Supreme Court of India. And joining me virtually are Dr. Amar Patnaik. Mr. Chadha, let me begin the program today with you to understand first the kind of changes that the new bill brings about to the existing framework.
First of all, this is not the first time that the competition law is amended. We all are aware that this is, I think, the fourth time, right. 2007, 9 and 19. First endeavor for which it was done is to bring the international, what are the best international practices which are there, so incorporate them. Then very important is that we see that litigation takes time. So not only time, of course, money also. So there are very nice things which have been added, like to begin with, settlement and commitment process has been started, where without going into the deep litigation, where the parties are said that please settle it, pay the penalty, a reasonable penalty will be paid, and then you make a commitment that such exercises, such things you will not be doing. That is another very important, I think, aspect of this particular bill. Then leniency, which we have seen. A concept, I'm just correlating, yes. A concept of, we see that you must have heard of a concept of approver in criminal law. So that concept is added here, where, out of, let's say, there are 5-7 people are there, 5-7 industries are there who are in, they come before the commission. One or two or become approver, as in the very normal language I am saying. So a leniency will be given to them, and it is not like in criminal law, it is one approver only is enough. Here, if other people are also coming, they are settling, they will be taken, and the matters will be settled, in a peaceful, in a very subtle manner, so that they make a commitment. And they, of course, they settle the dispute also. This is another very, very, very important aspect, I feel. Then trust is given more value. Now, we have to see that, because these are the backbone of our economy. We have to, both aspects are very, very important. There is no compromise that we are doing, but yes, trust is given importance. Now, as far as the digital economy is concerned, we have seen that digitally we are growing so fast. So there are a lot of changes, so that we are like earlier, if there is a some claim, some dispute has to come. So earlier there was the asset should be 300 crores, the turnover should be 1,000 crores. Such big events were. Now, in that, we have seen that so many companies were missing. Asset 300 crore is not there. So, what the government has done, they have taken now a deal is to be taken into consideration, and a deal size will be taken into consideration, not in addition to these two, as I said. The deal size should, if there is a deal size which is above 2,000 crores, it will be a prior approval is needed, and where the commission will look into it. So
certainly.
many teeth are given.
So how does it empower the CCI is something that I'll go across to Mr. Ahead of the break, we left at the concerns, the challenges that may arise. And let me bring in Mr. Chadha again into the discussion to try and understand what kind of concerns could arise once the roles are notified. Could there be opposition that consideration of total turnover may lead to unfair, punitive outcomes, that there would be voices which will say that this is discrimination between enterprises who commit a similar contravention but are penalized differently depending on the expanse of their businesses? Could that be a concern that could arise?
Look, we have to see it from the angle that, as per the new law, dominance is not bad. Being big is not bad. The only aspect which is very relevant is that abuse of dominance is bad. If you are dominating and then you are also, abusing your power or your bigness, as we can say, then that is wrong. And there I feel, certainly this amount of 2,000 crore, as Mr. Sharma was saying, that it is going to be little, opposition might be there. But as Dr. Patnaik has very rightly said, that these are very comprehensive, and initially when he said that it is about the welfare, yes, if there is a dominance which is being abused, it has an ultimate impact on the welfare of people. It has impact upon the general people if some big dominant power is using something, or misusing rather its power. So yes, there are chances that there might be a little concern about it.
Okay, Chadha, I'll take one last comment from you. The fact is, each of our laws look absolutely, brilliant on paper. But the key lies in the implementation. So once the rules are notified, it all comes down to how they are implemented, whether all the loopholes that have existed in the past are plugged. So in terms of implementation, do you see that we will be, we will live up to the mark? Because change has to happen, but it's important that that change happens timely.
Look, very, very important as far as any legal aspect, any law is concerned. Why a law is needed? Because of the change in the society. It was these changes, the major changes which we discussed in the show today, they were need of the hour. And accordingly, they've been implemented. Now, I think, when the rules will be out, it will be implemented. And then I think if something new will come up, that will also be rectified or corrected. That is why the process of amendment is accepted and is being basically, look, the difficulties like time-bound nature now, they have reduced the time from 7 months to 5 months. Why? Because this is the need of the hour. The companies need not to waste time in litigation and coming before the commission. They should work on the progress. They should move on with their business. So yes, very correctly you have said that these laws were the requirement. These changes were needed, and that's what I think immediately, as she has said, that the law has been very, very, and as Dr. Patnaik has said, that very rightly the committee has discussed each and every aspect, though it was passed in minutes in the parliament because of the various other reasons, but the committee has really devoted good time, and it's really congratulations to Dr. Patnaik and the team.
Namaskar viewers, hello and welcome to Sansad TV. I am Tina Jha. You're watching Perspective. The Competition Amendment Bill 2023 has been cleared by both the Houses of Parliament. The Rajya Sabha passed the bill on Monday by a voice vote. The Lok Sabha had cleared the bill last week. Now, this was a key legislative agenda of the government for the current session of Parliament, as it seeks to revamp the competition law and bring it in sync with the new economic practices and issues. The new law will empower the Competition Commission of India, giving it the ability to penalize entities found engaging in anti-competitive behavior based on their global turnover. So in Perspective today, we will look at the changes that the bill brings about to the existing framework and who does it impact the most. Joining me are distinguished guests. So let me begin by introducing them to you. I'm pleased to have with me in the studio Mr. Sanjay Chadha, Senior Advocate, Supreme Court of India. And joining me virtually are Dr. Amar Patnaik, Member of Parliament, and he's a member of the Parliamentary Standing Committee on Finance. Mr. Dhanendra Kumar, former Chairman, Competition Commission of India. Mr. Kumar, delighted to have you with us on the panel. Ms. Deepshikha Sikarwar, Senior Editor, The Economic Times. Ms. Sikarwar, thank you very much for joining us. And Dr. S.P. Sharma, Chief Economist and Director of Research, PhD, Chamber of Commerce and Industry. Dr. Sharma, thank you for your time as well. But before we begin the discussion, let's take a listen in to what Finance Minister Nirmala Sitharaman said on the floor of the House while moving the bill for consideration and passage.
The Competition Amendment Bill 2023, Srimati Nirmala Sitharaman to move a motion for consideration of Competition Amendment Bill 2023.
Sir, I rise to move that the bill further to amend the Competition Act 2002 as passed by the Lok Sabha be taken into consideration.
Srimati Nirmala Sitharaman to move the bill.
Sir, I rise to move that the bill be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. The bill is passed.
So an important piece of legislation passed by voice vote amid the din, as you just heard. Mr. Chadha, let me begin the program today with you to understand first the kind of changes that the new bill brings about to the existing framework.
First of all, this is not the first time that the competition law is amended. We all are aware that this is, I think, the fourth time,
right.
2007, 9 and 19. First endeavor for which it was done is to bring the international, what are the best international practices which are there, so incorporate them. Then very important is that we see that litigation takes time. So not only time, of course, money also. So there are very nice things which have been added, like to begin with, settlement and commitment process has been started, where without going into the deep litigation, where the parties are said that please settle it, pay the penalty, a reasonable penalty will be paid, and then you make a commitment that such exercises, such things you will not be doing. That is another very important, I think, aspect of this particular bill. Then leniency, which we have seen. You know, a concept, I'm just correlating, a concept of, we see that you must have heard of a concept of approver in criminal law. So that concept is added here, where, out of, let's say, there are 5-7 people are there, 5-7 industries are there who are in, they come before the commission. One or two or become approver, as in the very normal language I am saying. So a leniency will be given to them, and it is not like in criminal law, it is one approver only is enough. Here, if other people are also coming, they are settling, they will be taken, and the matters will be settled, in a peaceful, in a very subtle manner, so that they make a commitment, and they, of course, they settle the dispute also. This is another very, very, very important aspect, I feel. Then trust is given more value. Now, we have to see that, because these are the backbone of our economy. We have to, both aspects are very, very important. There is no compromise that we are doing, but yes, trust is given importance. Now, as far as the digital economy is concerned, we have seen that digitally we are growing so fast. So there are a lot of changes, so that we are like earlier, if there is a some claim, some dispute has to come. So earlier there was the asset should be 300 crores. The turnover should be 1,000 crores. Such big events were. Now, in that, we have seen that so many companies were missing. Asset 300 crore is not there. So, what the government has done, they have taken now a deal is to be taken into consideration, and a deal size will be taken into consideration, not in addition to these two, as I said. The deal size should, if there is a deal size which is above 2,000 crores, it will be a prior approval is needed, and where the commission will look into it. So
certainly.
many
So
Many
You're right.
teeth are given.
So how does it empower the CCI is something that I'll go across to Mr. Kumar in just a moment. But going first to Ms. Deepshika Sikarwar to understand, because what Mr. Chadha says, Ms. Sikarwar, the fact is it's not the First Amendment, it's perhaps the Fourth. But through the kind of changes it has brought about, or it will bring about once it becomes a law, can we say it's the most comprehensive amendment that the government of India has undertaken to the competition law in the country?
Definitely, Tina. This set of amendment, they have come after a while, and we've seen tremendous changes in the functioning of the corporate sector. New kind of businesses have surfaced, which the law was unable to take care of. The kind of practices that they were engaging in. So these amendments have tried to take all those developments into account and have tried to address the concerns that have emerged, particularly with regard to what was happening in the e-commerce, the digital platforms sectors. There were other issues. A very significant amendment has been brought about in form of these settlements. So the law is being amended to reflect the changes, not just in India, also the practices which are going around in the globe, also take into account the global best practices globally.
Yes.
So these set of amendments are very, very comprehensive and make the law much more relevant to today's times.
Okay. Dr. Kumar, how does the new bill empower the Competition Commission of India? Because what we when we look at the report, we understand that the CCI is set to gain the more, perhaps it's been afforded abilities of different kinds in different aspects. So if you could help us and our viewers understand about the manner in which the CCI is set to get empowered once it becomes a law.
Thank you. First of all, thanks for the opportunity given to me today. Let me say that it is the first substantive amendment in the competition law after the enforcement began in 2009.
Right.
The enforcement actually began in May 2009 after the commission was fully constituted and an appellate tribunal was put in position.
Yes.
Now, after that, it was noticed that the shape of the market has changed considerably with the advent of new technology and with digitization, and the existing act was not in a position to capture everything because of various factors. There were situations when companies were becoming dominant by accumulation of data and by network effect and so on. And many things were not captured by the various provisions. So this new bill, which has been enacted now, which was enacted, the committee was constituted, Competition Law Review Committee, under the chairmanship of then Secretary Injayati Srinivas in 2018. And on their recommendations, a bill was drafted, submitted to the Parliament, and it was sent to the Standing Committee, and we have Mr. Amar Patnaik, a distinguished member of that committee with us today. And on the basis of those recommendations, the government thereafter sent its new bill, and it has been passed by the Lok Sabha on 29th March and the Rajya Sabha on the yesterday on the 3rd.
3rd of April,
now,
yes.
the major amendments, let me quickly roll out, which would show that it would plug in many loopholes. Just for example, the earlier bill had this problem that in the digital platform these days, the entities, they grow dominant very rapidly. And to give you an example, that Facebook had acquired WhatsApp in 2014. And at that time, the assets and turnover of WhatsApp was, I would say, minuscule in proportion to the amount by which it was acquired. It was acquired for $18 billion in 2014, while the actual turnover at that time of WhatsApp would have been a few $million. Now, they had an eye on the potential and the technology and data it would bring in. So, and it has really benefited them. So, it has been captured now in the new amendment, that deal value threshold above 2,000 crores. Now, if there is any deal, it would have to be mandatorily reported to the Competition Commission, who would look into it, the anti-competitive aspects and so on. It's something not new. It exists similarly in USA and so on. Now, settlement and commitment is something, again, which is existing in many jurisdictions, and it's very, very important that we should not only focus on imposing penalties, but the focus should be on bringing in market corrections, which is the main objective of the existence of the CCI. Now, the existing the penalties which have been imposed so far, about 17,000 crores worth of penalties, the actual recovery has not been even 1%. Now, with this commitment and settlement thing being brought in, it would be possible for the companies to enter into a commitment in the beginning if the matter has not been, if the DG has not submitted his report, and settlement if DG has submitted his report, but CCI has not yet passed the order. Okay. So in either of the situation, the companies can enter into a settlement kind of a thing. And it is not, again, something unusual. It happens in taxation, it happens in SEBI, Vivad Se Vishwas and all that. So all those things are there right now. And this would help in releasing energy and the time and resources of the companies as also the CCI. So again, and the third thing, which is in my view very important, is the global turnover. Now in the digital economy, again, it is all interconnected, the digital economy. Absolutely. And what is happening somewhere, it would have impact elsewhere also. So to make it a global turnover, although it may look a bit punitive or deterrent, but yes, this would also for the multinationals, and it's not only the digital enterprises, but also automobile companies, like for example, Toyota, Hyundai and so on, they have operations all over the world.
You're right.
Now,
so we'll talk about the impact in just a bit from the business point of view. We'll get in views from Dr. Sharma. But Dr. Patnaik, we've spoken about these amendments and comprehensive amendments that have been brought about and which Mr. Kumar says will plug a lot of key holes on mergers, on acquisitions, on the penalty aspect also. Were these the recommendations that the parliamentary panel had made, of which you were part of? Or in the final draft, do you see certain modifications that the government of India has come up with?
Thank you, Tina, for inviting me to this. This is very fresh because it was just passed yesterday by a voice vote. But while in the Standing Committee on Finance, we had really spent long hours looking to the government's proposal for those amendments, which were actually, as Mr. Narendra Kumar said, it's actually the most substantial amendments after 2002 have come by way of these amendments. So we spent a lot of time and consulted a number of stakeholders, including business, MSMEs, the big tech firms, the publishers. We have consulted, we have had a huge round of consultations. So what we really basically looked at this entire issue is from the way competition has changed. The physical market and the digital market. So the digital market, the way it operates, as Dr. Narendra Kumar said, is about, it is through network effect, bundling of services, through use of data, predatory pricing, number of issues. So in our report, we have in fact identified 10 anti-competitive practices. It talks about steering provisions, platform neutrality, bundling data uses, deep discounting, exclusive tie-ups. This came from the hotel industry. Search and ranking preferences, the reviews that you see. So we have really identified 10 such anti-competitive practices.
Right.
And therefore, we thought that the amendments which were introduced by the government was long overdue, was in time. In fact, it is long overdue, as I said. But we made certain changes. Now, we made recommendations for certain changes. First thing and the foremost, keeping the huge implication that the big tech have in the Indian market, we have first recommendation was for ex-ante kind of a framework rather than the post-hoc framework that we have. The current framework, even after these amendments, is actually post-hoc. After something has happened, it will be reported. Or through the commitment and settlement system. I'll talk about it a little later. So we have basically said that time has come for ex-ante legislation, as they have in the European Union through the Digital Markets Act. And the government have reacted to it by setting up a broad-based committee which is looking into it. So I'm looking forward to having a separate bill or a further amendment to this these Competition Act sooner than later. The second set of suggestions was improving on the amendments which had been suggested by the government. And I must tell you this, most of it were accepted and therefore brought in as a separate bill in 2000, and that is the 2023 bill rather than the 2022 bill which was introduced. Now, these refer to, for example, we said that if you are having a merger and acquisition or a combination, then what is important is the target company. And it is not important that you acquire something who has no presence in India, so it doesn't really matter. So the target company will be the one which will be facing the local test context. So that was a change which was accepted by government and brought in. Then there was this question of, of course, the deal value. We had a lot of discussion on this. The deal value, whether we should have the 2,000 crores fixed and coded into the law, or should we make it flexible so that the government could revise it from time to time, one, and whether different sectors require different set of thresholds. As it has been discussed here, that in the big tech space, deal threshold makes eminent sense because asset and turnover, you can't probably have many companies coming out of the competition rigor if we only follow the assets or the turnover. So deal value is very right, but whether we should have hard-coded 2,000 crores in it, this was a recommendation. Government has not accepted and continued with its earlier recommendation of having it hard-coded into the law. The third kind of recommendation was relating to the timelines, and of course there are many administrative issues which were discussed relating to vacancies. But one important issue which we talked about, and which the Supreme Court, which the Law Ministry has finally said, is the doctrine of necessity. If you do not have members, you need 3 members to fulfill full decorum there. If you do not have, the Law Ministry has opined in February 2023 that you could still go ahead. You don't have to completely, the CCI need not be completely coming to a standstill in hearing judgment. Now, this I thought could have actually come into the bill. The other suggestion was on the settlement. We have it on the commitment and settlement. Let me make it very clear here. The commitment process comes before the DG initiates an investigation. Right. The settlement comes after the DG has initiated the investigation. So we thought that maybe even if you have an elaborate system, and it's a very, very timely, required, and as Mr. Narendra Kumar said, it's basically to correct the market. But whether it will actually work, because if the player feels that once I get into the settlement process, then it will be almost construed as an admission of guilt, because the provisions do not provide for the player to come out of the settlement process suo motu on its own. We had made that recommendation. That was not accepted. It is only the CCI which will reject it. So this is again one thing which we thought would have come in. Okay. But then there are many small changes that were made on the basis of the suggestions given by the committee, which is, for example, relating to who can the DG call for evidence. There was a big question whether external legal support or lawyers who are appearing for a player would also be asked to share information under oath. So that was clarified, I think, through an explanatory note saying that it would be only those law officers who are internal to the organization, who are in the internal legal wing of the organization, they would be asked to depose, so that the client lawyer relationship that is provided for in the Evidence Act is not frustrated. So that change was brought in again because of the parliamentary committee's recommendations. So this was accepted in fact.
Right. So a number of recommendations that the panel made, which have been accepted. There have been certain additions to it also that we see that the government has made. But from a business point of view, Dr. Sharma, if I may bring you in now into the discussion, how are these changes being looked at and who is set to be impacted the most now?
Thank you, Tina. And we welcome the bill. Because ease of doing business and regulatory environment, strong regulatory environment are the most strong ingredients of the economy. And as we move forward, as India is becoming more and more visible in the global charts, and we are the fastest moving economy, so amendments also go hand in hand with the growth and development of the economy. And we welcome the bill. There are a lot of developments and amendments, and these are favorable for the economy as now world is changing, markets are changing, and we change every day, and world is so dynamic that we have to move forward with more and more strong ease of doing business and regulatory environment. If the industry needs ease of doing business, then there must be strong regulatory environment also. So we are in favor of the strong regulatory environment also and the ease of doing business, so that because India is a diverse country, we have every kind of people, every kind of businesses. We have the richest people also, those who are in the world, the richest list, and we have the poor section of the society also. So we have to come out with the welfare generating policies which are regulated adequately by the government, and the welfare in terms of ease of doing business and ease of living is also provided to the people and the businesses. So we fully agree, and I agree with all the connotations made by the esteemed speakers, because this bill is going to place India in a most attractive destination, as we are going to become $100 billion FDI destination shortly, and we are already $85 billion currently. So moving ahead, as we have to attract more and more investments from the foreign markets, so the global participation in India's economy, as we are the fastest moving economy, becomes more and more important. And ease of doing business and regulatory environment, they have to support the growth of the economy and the attractiveness of the economy towards the global players. So I think challenge should not be there, but the global turnover criteria, I believe there will be some representations. Though so far we have not received any connotation from the industry leaders on the same.
Now, with the Rajya Sabha passing it on Monday after the Lok Sabha passed it a week ago, the Competition Amendment Bill 2023 awaits presidential assent. A quick review of what the bill seeks to do. It seeks to amend the Competition Act of 2002. The 2023 bill tries to bring the competition law in line with new economic practices and issues in the country. It decriminalizes certain offences under the Act by changing the nature of punishment from imposition of fine to also civil penalties. Now, these offences include failure to comply with orders, Competition Commission of India and directions of the Director General related to anti-competitive agreements, and also abuse of dominant position. The key highlight is the amendment that empowers the CCI to impose stiff penalties based on global turnover of an entity for anti-competitive practices, something that we discussed ahead of the break. And transactions of over 2,000 crore rupees require the CCI's approval that will be given or denied within 150 days, down from the earlier limit of 210 days. Also, penalty for the abuse of dominant position has been made to 10% of the global turnover of the entity, or 3 times the company profits for the last 3 preceding financial years. Now, this is also significant. For earlier, the turnover related to only the domestic entity, something that we've understood from Mr. Chadha in the earlier round of discussion. So the amendment could potentially impact multinational companies in India as well as Indian firms with a global presence. The bill further expands the scope of entities that can be judged to be a part of anti-competitive agreements. Currently, only enterprises or persons engaged in similar businesses can be held to be a part of anti-competitive agreements. Also, the bill expands to include enterprises or persons who are not engaged in similar businesses. It has also introduced a green channel route for certain combinations that shall be eligible for deemed approval in a trust-based framework upon filing of a combination notice. So this was a quick review of the kind of amendments, the changes that the new Competition Amendment Bill 2023 will bring about once the rules are notified. But ahead of the break, we left at the concerns, the challenges that may arise. And let me bring in Mr. Chadha again into the discussion to try and understand what kind of concerns could arise once the rules are notified. Could there be opposition that consideration of total turnover may lead to unfair, punitive outcomes, that there would be voices which will say that this is discrimination between enterprises who commit a similar contravention but are penalized differently depending on the expanse of their businesses? Could that be a concern that could arise?
Look, we have to see it from the angle that, you know, as per the new law, dominance is not bad. You know, being big is not bad. The only aspect which is very relevant is that abuse of dominance is bad. If you are dominating and then you are also, you know, abusing your power or your bigness, as we can say, then that is wrong. And there I feel, you know, certainly this amount of 2,000 crore, as Mr. Sharma was saying, that it is going to be little, you know, opposition might be there. But as Dr. Patnaik has very rightly said, that these are very comprehensive, and initially when he said that it is about the welfare, yes, if there is a dominance which is being abused, it has an ultimate impact on the welfare of people. It has impact upon the general people if some big dominant power is using something or misusing rather its power. So yes, there are chances that there might be a little concern about it.
Okay, so let's see once the rules are notified what those who are being impacted, they have to say whether they're going to challenge it. But Mr. Kumar, coming back to you again, it proposes to cut down the timeline for approval of combinations to 150 days from 210 days. Yes. Were there apprehensions, or will there be apprehensions within the CCI, which already claims to be an understaffed commission? Does it add to their burden?
Well, let me first of all mention that when we initiated the combination review process in 2011, the enforcement of antitrust cases had started in 2009 May, as I said. Review of combinations started in 2011. Now, we had assured the industry at that time that we'll try to clear 95% plus cases within a period of 30 days. And I must say, to the credit of Competition Commission, that they have adhered to it, and almost 95-96% cases are cleared within that time period. Only a few cases go beyond that, and the limit of 210 days, which you mentioned, has also been strictly adhered to in those cases. I don't think there would be any problem at all in adhering to the 150 days limit. In any case, this is to give an assurance to the concerned parties that it will be cleared. There is also a provision there that CCI has to make a prima facie view within 30 calendar days, not 30 working days. And if it is not given out, then it would be deemed to be clear.
Yes.
So overall, the emphasis is on speed and ease of doing business. But just one more minute, since you mentioned about the global turnover part, that this could be a matter of concern. Let me tell you that it is just the outer limit. CCI has to decide based on the facts of the case, and there are attenuating circumstances, there are mitigating circumstances. It could be, it has happened in the past, it could be 0.1%, it could be 10%, it could be 0.01%. So depending on the situation, circumstances, it could be low also. The global turnover need not be taken as the benchmark. It is the outer limit. So I don't think that the company should feel frightened of this limit, and it will not be generally the matter that And by the way, in global arena also, many jurisdictions in advanced countries, they also have similar limits.
Okay, okay. Dr. Patnaik, the other aspect is expanding the scope of settlements to include the cartels. What is the kind of recommendation that the parliamentary panel had made in this regard? Or were there also arguments made against it?
Yeah, before I come to this, I'll just add make one statement relating to the global turnover. You see, the bill decriminalizes a number of offenses. And therefore, in fitness of things, therefore, it had to also bring in the penalties much stiffer. And therefore, the global turnover. One reason why and which is in the nature of a fine, whereas earlier it could be a criminal offense. So it had to do a balancing act, and this has been done. The second point is, if you realize that there are a lot of multinationals, big tech companies operating in India who are using the network effect, bundling effect. Network is not just within the country, is globally they are having it. So therefore, the global turnover, as Mr. Dhananjay Kumar said, it's actually there across several jurisdictions. So that has been brought in, and I think that rightly so. Now, to your question relating to cartelization, what the law says now that it is going to identify a vertical cartelization, hub and spoke models. There are some companies which follow this model to establish their dominance, or sorry for using wrongly the word. In fact, Sanjay Chadha says very correctly, dominance is okay, but abuse of dominance is what is antitrust. And so in this case, vertical cartelization has been addressed. The committee felt that horizontal cartelization should also have been addressed, but this was not accepted by the government. They feel that horizontal cartelization can be addressed within the meaning of the existing sections and existing rules. But on cartelization, if they are going in for settlement, they cannot. So they are not to be accepted. Their application for settlement will not be accepted. That is what we had recommended in the committee, and we had, of course, recommended for also clamping down on horizontal settlement, which was not accepted. This is as far as settlement is concerned. And of course, we had said, as I said earlier, that if somebody wanted to withdraw from settlement, then he could be given 7 days' time or 15 days' time. That was not accepted by the government.
Right. Okay, Ms. Deepshika Sikkarwar, coming back to the penalty aspect, because that is something that has been the most talked about since the bill got passed. What we've seen in practice is that the CCI seldom imposes the highest penalty. And going forth, also, there is a view that it will be mindful of imposing penalties, especially on big companies. But at least it gives an opportunity to have and lay down guidelines which will reduce abuse of dominance, as we've been discussing. And to that aspect, by when do we expect the rules to be notified and the law to come into effect?
Tina, as you know, a lot of work has the ministry has already been working on execution of the law. So once it receives presidential assent, I think they will quickly go on, finalizing the rules framework. And some of the parts of the rules which they are going to come out, from what we understand, they would seek public comments on them before actually they implement them. But in these set of amendments, Tina, government's done a very balancing act and it's a two-pronged approach. On one hand, they have tried to empower CCI more, taking into account the developments in the domestic industry, domestic technology, and also take global best practices, and also introduced a number of facilitative measures for ease of doing business. So all this, and especially the focus has been on ease of doing business, besides empowering, giving more teeth to CCI to handle newer developments. So when the rules are framed, they would also be put out for public consultations to ensure that, if there is, if industry has some concerns, or if stakeholders have some concerns, they can be taken into account before, the rules are implemented.
Okay, Dr. Sharma, what are the concerns that the industry could have once, when the rules are notified, as is practice, it is open for public consultation, there are suggestions that are sought from all stakeholders. So what are the concerns that the industry is expected to highlight in this particular case?
I fully agree with Deep Shikha because there must be some industry perspective, also industry viewpoint on the same. As the big picture is very good and very lucrative, but there must be some connotations at the micro level also, so that bill becomes more and more important for the growth and development of the economy, and it goes with the ease of participation in the global economy. So I think so far there is no concern from the industry side because the bill is just passed. But going forward, I think there must be some representations from the industry side, so that this becomes in sync with the thought process of the government and thought process of the businesses for the growth and welfare of the society.
Okay, Dr. Chadha, I'll take one last comment from you. The fact is, each of our laws look absolutely, brilliant on paper. But the key lies in the implementation. So once the rules are notified, it all comes down to how they are implemented, whether all the loopholes that have existed in the past are plugged. So in terms of implementation, do you see that we will be, we will live up to the mark? Because change has to happen, but it's important that that change happens timely.
Look, very, very important as far as any legal aspect, any law is concerned. Why law is needed? Because of the change in the society. It was these changes, the major changes which we discussed in the show today, they were need of the hour. And accordingly, they've been implemented. Now, I think, when the rules will be out, it will be implemented. And then I think if something new will come up, that will also be rectified or corrected. That is why the process of amendment is accepted and is being basically, look, the difficulties like time-bound nature now, they have reduced the time from 7 months to 5 months. Why? Because this is the need of the hour. The companies need not to waste time in litigation and coming before the commission. They should work on the progress. They should move on with their business. So yes, very correctly you have said that these laws were the requirement. These changes were needed, and that's what I think immediately, as she has said, that the law has been very, very, and as Dr. Patnaik has said, that very rightly the committee has discussed each and every aspect, though it was passed in minutes in the parliament because of the various other reasons, but the committee has really devoted good time, and it's really congratulations to Dr. Patnaik and the team.
Okay. Mr. Kumar, time allows me to take up quick remarks from you, concluding remarks. Now, the next step is how effectively it's implemented. How geared up is the CCI to incorporate these changes? Because a lot of onus lies now on the Competition Commission of India to make these changes into a reality.
Absolutely, you said it. Let me correct technically, rules are made by the government, that is the Ministry of Corporate Affairs. Regulations are framed by the CCI.
Commission, CCI.
Yes.
And CCI would definitely frame the rules. Wherever necessary, it will put them in public domain to invite comments. Right now, there is a little problem because chairman's post is vacant, but I'm sure it's going to be filled up soon. But CCI is working and they should be making the regulations soon. Altogether, I think the picture is very clear what needs to be done. Everyone knows about it. Industry also, and again, I could possibly take a moment to compliment most sincerely the committee, Mr. Patnaik and his colleagues. They have done a brilliant job over a short period of time, within about 3 months or so.
Yes.
Heard everyone, all the stakeholders, and they have brought in all the perspectives in the matter. And I feel everyone knows what is to be done, and I am looking forward to very smooth implementation of the act going forward now.
And for that, let's hope that the problem of the commission being understaffed is resolved at the earliest. Yes, Dr. Patnaik.
That's the point that you just mentioned. I think the pudding lies now in filling up these vacancies. The 69 positions, we have mentioned it in our recommendation. And what is important that even though 96% of the cases have been resolved, what's the time period taken? 3 years on an average. So I think the effort, you can see that from the structure of the amendments, the effort is to decrease this time period so that the ease of doing business improves. So we really have to fill up those positions. The doctrine of necessity will be helpful. If it is required, then the numbers of positions in the CCI could be increased. And another most important thing is that appeals. There are several of the CCI's orders which have gone in appeals, and not just at NCLAT, but even at the Supreme Court level. At the NCLAT level, about 45% have been cases have been actually turned down. They have turned down the orders of the of the Competition Commission. So I think a lot of it will depend on building the capacity of the CCI and its staff, using the right DG and its staff, putting in the time frames within which all this should be done in a time-bound manner. And I think the rules should not be again made in such a manner that the appeals would just sustain because of the arbitrage it is given because of the difference between the act and the rules. So I think these issues, if they are addressed, the whole purpose and objective of bringing in these transformational changes in the form of amendments would be achieved to the India Inc.
Absolutely. So the whole point is that the purpose is achieved because of which these changes that were the need of the hour have been brought about. Now the proof of the pudding lies in the eating. So let's hope when the rules are notified, there are adequate representations made in terms of the changes that all stakeholders would like to see. But once implemented, once the rules are out, they are implemented with the manner in which the kind of impact that that the government hopes to make through this bill. So that having been said, I'd love to wind up the program. I would like to thank all my guests for joining me on this edition of Perspective, sharing your thoughts, your view with us and our viewers. And to you viewers, thank you very much for your time as well. I'll see you same time tomorrow now. Take good care of yourselves. Keep watching Sansad TV.